Just remember, if we don't like the answer, this microphone shocks you.
Okay. If I get shocked, I quit. Leave it. I don't.
There they are.
I don't.
You want some tobacco,
Sir? Now you got a light?
Let's just wait 1 minute so we can get the inside rolling in there.
Thank you. Mel, I'm glad you thought of that. Nobody else would.
All right, gentlemen, we have 15 minutes. That was the ground rule, so. Q&A.
Judge,
Yes, sir.
what kind of reaction, or we couldn't see Mr. Bundy's face as he stood being sentenced. Could you tell us how he reacted and what your feelings were as it happened?
I think I tried to intimate to, or tell to Mr. Teller that particular concepts of the case and insights to the case, I don't think are really appropriate for me to comment on because we've got motions that are pending before us now and various other factors. It's difficult to read reaction or anything like that, but
You personally think he's guilty?
do I personally think he's guilty? I don't think that question is appropriate to ask the judge. I wouldn't have sentenced him if I hadn't, because the jury made the finding.
Is that the most difficult decision you as a judge face, the sentencing, the final moments of a trial?
I think without a doubt the most difficult proceeding there is sentencing from a pure judicial standpoint.
Judge, were there any surprises to you in the trial? Anything that surprised you at any point in the trial?
Not per se during the trial, no.
Judge,
Excuse me, Mr.
Judge, you made some mention about the law not being set in concrete or inscribed in concrete, that is the capital punishment law. Would you like to elaborate on that and your feelings perhaps about capital punishment?
Mr. Larson, there probably is nothing as vacillating in the world as legislatures. And that's the reason for the comment. It might be changed, it might be altered. Supreme Court might make different concepts. Personnel, judicial personnel change, thoughts change on high benches. Anything is conceivable. But of course, as a trial judge, you take the law as it is at the time you make the decision, or you think it is. And that's the concept. It's not a breath of hope, or it's not an expression of personal feeling. It is simply is a fact of life that conditions change. The law is an organism. We hope it remains an organism. That's the intrigue about it. Sort of like your business. There's something that comes along basically every day, and it is an organism.
Judge,
Talking about our business, what did you think of Mr. Bundy's attack on the press? He seemed to blame us for his plight.
Well, I guess you can say it's an old thing. As a old-time lawyer, when you got a client that you're worried about his guilt or innocence, try everything in the courtroom, including the court. I don't have much comment about it. I didn't have any problem with the press. I thought all of you conducted yourselves the way that I expected you would, and anticipated you would, and really knew you would.
you talked just a moment ago about the changing ideas in the legislature. These decisions, of course, are retroactive then if they make them.
Might or might not be, Milt.
Now, this is something that buoys these people up while they're fighting. It takes 3 or 4 years before the conviction and signing of a death warrant, doesn't it? Before
Sometimes longer than that.
Judge?
Yes,
You
sir.
seem deeply concerned about mitigating, or the lack of mitigating evidence presented by the defense, especially Dr. Tanay's findings. Could you explain that to us a little bit?
Well, that's fairly well set out in the judgment, the feelings that we had on it. We kind of commented within the framework of the Senate structure and that fact, and the ones that we alluded to. I really would suggest you sort of look at what we said. There again might be something that I've got to talk about in the future, you know, and it's just that what we set forth in the findings and in the sentence, as the written sentence as prescribed by law, is the way we feel.
Judge, might we expound on a question before? Mr. Bundy complained not so much against the press itself, it seemed, but the magnitude of the satellite transmissions and the incredible, just the sheer amount of stories that went out to so many markets all over the country. And I wonder if you had thoughts in that respect, that the sheer amount, and magnitude of the press coverage really hurt his chances at a fair trial, and that by being there's an inference of guilty. Did it hurt his chances for a fair trial?
I don't think that there was, when you're operating under the guidelines that we have, what happens once that it's disseminated and left the courtroom should not and does not, in my opinion, have any impact. If the jury were not sequestered and were reading it all, I could see the possibility of it. But there are safeguards and there are procedural matters that you invoke for the protection of that. I don't see, and I guess I've expressed this previously, a direct combat between the First and the Fifth Amendment. We've said that many times. Our Sixth Amendment, our Fourth Amendment, they're all basically engrossed in it.
Overall, Judge, did he get a fair trial, considering the jury process, considering things you did and felt had to do? Was it, in your experience?
I think you're probably a better judge than that. I don't know of any decision I would change that I made, if that helps you any.
Judge, you were privy to much more information than the jury could actually hear in this case. And did that additional information that you knew about the circumstances concerning the crimes make the job of sentencing any more difficult, any easier, any more clear?
We didn't use anything that, as we said under Gardner, that which is a pretty controlling case, that was not known to the defendant. Certainly there are things that the jury wasn't privy to during the guilt or innocent phase that we have to suppress. We felt that the law requires suppress under the exclusionary rule. But those factors, when we exclude them, we only review for the purpose of looking at the whole and total record when you sentence, that's all.
Aside from the sheer magnitude of the coverage, do you regard this to be an unusual trial or in any respect, and if so, how?
I don't think it was per se an unusual trial. It was a protracted trial. Most all trials are unusual in that they're different people, they're different personalities, there are different factors involved in them from the standpoint of evidence, from the standpoint of police work. I think we started at the first concept of this, that our hope and our aim was to try to put this concept into a basic simple trial, and none of them are simple when you got a charge of first-degree murder. Yes, sir, I'll be with you.
All right. Your Honor, you said in your goodbye to Mr. Bundy that you're a bright young man. It would have been good if you could have ever practiced in front of me. How do you rate Bundy as a lawyer in the he conducted a large segment of his own defense?
The answer to that is he really isn't a lawyer. He's never gone through all of it. In the aspect that he's saying, Mr. Bundy is very articulate, very personable. Basically, on this side, as we saw him under the courtroom structure, human being, and to that degree, we feel that. I feel strongly that way. You've got the comments that I made in the courtroom, and I think I indicated that. I think he indicated that. Yes.
Judge Cowart, do you have any idea how much Dade County taxpayers had to pay for this trial?
I can only answer that like I will tell you that all the other costs, there's none that will be taxed that weren't necessary for a pure, fair, and impartial trial.
Judge.
Only additional costs have been by virtue of jury sequestration, and this little gathering here is one of the strong reasons that those costs were necessary. So I don't have any factor on, I don't have any idea on
Would
that.
Leon County help bear the cost?
Boy.
Judge, do you expect your sentence to be carried out?
Do I expect it?
Yes.
I certainly don't hope you think that I sat there and exercised something in futility.
No, but given the context of the political situation these days, do you expect the death penalty to be in effect by the time it happens?
One of the first things that you learn in the legal business that not to prognose the legislative, and I just don't know the answer to that. I don't say that to you in curtness. I say it to you because, as we talked about previously, legislative ideas and concepts change.
How soon do you think it would happen, a sentence of death could be imposed? How long does it take in the legal process?
I don't know. We've got some that have been there 4 or 5 years. Yes, sir.
Judge, it seems fashionable nowadays for condemned men to withhold an appeal grant until their death warrant's actually signed. Is there any way that you can make sure that the appeal of ineffective counsel is brought up before?
That's a direct question on future proceeding. It might be before me. But if you go back and look at 2 or 3 comments we've made through the trial, you're going to find the answer to that.
Mr. Bundy said himself that he thought that you would impose the death penalty even if the jury recommended mercy. Was he correct?
He was correct in what his own thought was, I assume, but there's nothing that's binding as far as I was concerned. I didn't know what the jury was going to do. I didn't know what I was going to do.
Judge, are you concerned at all about the comments made by Mary Russo since the jury was released?
Well, that's
her concern about...
I can't comment on because I might have to rule on it.
Have you ever gotten to know a defendant in a criminal proceeding as well, perhaps as you've gotten to know Mr. Bundy?
Yes, sir. Sure have.
Judge, going back to the final comment you gave Mr. Bundy, it seemed like that you were genuinely emotionally touched by the prospect of sending a man with such a promise to death. Is that true? Were you emotionally touched?
I think he said it probably more eloquently than I said. Behind all that robe, you're still a human being. How can you not be concerned? How can you not be cut? It's not a pleasant thing to do. It's an obligation, just like when you answer a draft call. And the lieutenant says you climb over the hill, you got to do it, but it isn't something that you want to do or like to do. Certainly you're concerned with it. You'd be inhuman if you weren't, and God knows I'm human.
Concerning an appeal, if and when...
Pardon?
Concerning an appeal and the magnitude of the coverage of this trial, if and when there is another trial for Bundy, is there any place in the state of Florida, do you think, that they could get an impartial jury this time?
We can get a jury.
Where?
Where?
Tallahassee.
What about the letter from Margaret Bowman's father? Did you read that before you made the sentence?
No, sir, I still haven't read it.
Do you intend to?
Don't know where it's at. Yeah, you bet I'm going to read it, but I'm not going to read it yet.
Do you know which circuit appeals will be heard in this case?
Supreme Court.
Judge, were you speaking literally when you said a few weeks ago that you thought that Bundy's defense team was the best you had ever seen?
From a legal standpoint, and from a point-raising standpoint, and from a briefing standpoint, and from a numbers standpoint, absolutely.
What standpoint haven't you covered?
What standpoint? I don't know of any. I don't know of any.
Does that suggest, Judge, that you had before you defense teams that were less?
But I've had defense teams. I've had a lot of them less in number, my friend. I assure you that.
Judge, did you ever get the sense or feeling that Bundy was engaged in any kind of role-playing, that he divorced himself from the actual crime or the event, that he really considered himself innocent and that he was playing the role of a lawyer or something like that?
I didn't get such an intuition. I didn't get such a feeling. I might have. I don't know. I didn't look at that from that standpoint. Never thought about it. Really, I had some comment raised about it in, I think, the competency proceeding, but I didn't sense any such thing as that.
What feeling did you get then from his behavior and his attitude, demeanor in the courtroom?
Depends upon what day it was. I got quite a few feelings from it.
Let's tell you, I mean, an overall view of his capacity, his...
Well, what do you expect a man to do who's on trial for the charges that he was on trial with? If he didn't vigorously try to defend himself, something would be wrong with him. I don't see anything that that has impressed me concerning that. I really don't.
Two questions for you. We talked, right when you were first appointed on this case, we talked up in Tallahassee, and you said to me, calm down, this is just another trial. Do you still feel that way?
Sure do.
You do?
You sure do.
Just another trial.
Yes, sir.
The other thing is, might you be moving to Tallahassee to take a seat on the Florida Supreme Court?
I am running and moving toward obscurity. No, sir.
Not after this trial, certainly.
You bet I am. That's even more reason.
Thank you, Your Honor.
Thank you. Thank y'all be careful. Good to see y'all. Come back to see us.
I got your text. Got a leash on you.
I had a leash on you.
Tell me that.
Yes, sir. Watched every day. How long have you been on the bench, Judge?